United States courts have confirmed the idea that good moral character is a necessity for public school teachers and have frequently favored school districts in teacher termination cases resulting from alleged moral offenses. In Vigolkin v. State Board of Education, California teacher Nicholas Vigolkin was refused his request to have his teacher credentials reinstated. Vigolkin had voluntarily resigned his teacher credentials after being found guilty and serving probation for a sex-related crime. Vigolkin claimed to have been rehabilitated and fit to teach. Vigolkin claimed the legal code used to prohibit him from regaining his teaching credential was a violation of the Due Process and Equal Protection Clauses of the 14th Amendment to the Constitution of the United States and of the constitutional provisions of the state of California. The ruling against Vigolkin was monumental as it maintained the constitutionality of holding teachers to moral expectations. In its ruling, the court noted, "The school children of our land are the future of the nation. The innocent mind in a formative state is subject to the immediate influences surrounding the child. The material he is taught, the impression he gains, the events occurring, the actions which he sees or hears about, the surroundings of his daily activities are a part of his education and are formulative of his future." When a teacher is convicted in a criminal act, particularly a sex crime, the vagueness of the term immorality may seem moot. However, when a teacher's livelihood is threatened for issues that are not illegal and subjectively perceived, the imprecise nature of what is immoral becomes problematic. In April of 1973, tenured Alabama public school teacher Alina Drake was notified by mail that her teacher contract would be canceled the following school year due to, in the words of the Covington County School Board, immorality, and that the board has been presented with a physician's certificate stating that you became pregnant during the current school year, at which time you were a single, unmarried person. A hearing was held on May 22, 1973, at which Drake's doctor testified she was indeed pregnant, and Drake admitted having premarital sex with her fiancé. The school board subsequently voted to cancel Drake's contract. Drake filed a complaint in the United States District Court that the immorality provision that led to her dismissal was too vague, unconstitutional, and should be voided. The court ruled in favor of Drake, primarily stressing the evidence used to dismiss Drake was gathered in a way that violated Drake's constitutional right to privacy. According to court testimony, a bookkeeper for the school district shared a rumor circulating that Drake, an unmarried teacher, was in the hospital due to pregnancy. School district superintendent Murray King called the hospital's director to confirm if the rumor was true. The hospital director, Dr. Evers, confirmed that not only was it true, but also that Drake was in the hospital having an abortion for fear she would lose her job if her pregnancy were discovered. Superintendent King went to Drake's hospital room, informed her that he was aware of the pregnancy, and notified her that she would have to file notice of whether she terminated the pregnancy with the school board. Upon returning home from the hospital, Drake called King to notify him she was no longer pregnant. King followed up with Dr. Evers, who stated Drake was still pregnant. King informed Drake that she needed to provide doctor-verified proof that she was no longer pregnant for the matter to be dropped. When none was provided, King and the school board responded with notice of intent to terminate Drake's contract, citing immorality as grounds for cancellation of Drake's employment contract. In its ruling against the Covington County School Board, the court found the board made no finding that Drake's claimed immorality had affected her competency or fitness as a teacher, and no such nexus was developed in the evidence. Dissenting Judge Varner dissented with the decision, believing Drake's termination should be upheld. In his dissenting remarks, Varner explained, "The loss by a teacher of the respect of her students associated with her known pregnancy without marriage is, in my judgment, so obviously a deterrent to the teaching ability of such a teacher as to be within the judicial knowledge of this court." The Board of Education must have known that Miss Drake would have encountered grave problems. In my judgment, there was and is a compelling state interest justifying termination of Miss Drake's employment under the circumstances. In a case following the heels of the Drake case, longtime teacher and coach Richard Erb appealed after his teaching license was revoked for admitting to being involved in an extramarital affair. According to the initial complaint against Erb was hired to assist designing a store for Margaret Johnson, a home economics teacher who worked with Erb. Margaret's husband, Robert, became suspicious of the hours she spent away from home in the evenings. One night, he hid in the trunk of the family car before Margaret left for her evening shop work. While in the trunk, Robert heard Margaret and Erb having sex. Robert stayed quiet in the trunk and was able to remove himself from the trunk without notice when Margaret returned home. The next day, Robert consulted a lawyer who advised Robert to get proof of the affair. Robert assembled multiple friends who gathered and hid in areas where they suspected Margaret and Erb were meeting for sex. Eventually, the group caught Margaret and Erb and took multiple photographs of them through the car windows in partial undress. Erb offered to resign from his teaching position following the scandal, but the school board unanimously refused the resignation, citing Erb's high quality as a teacher, and that he had been forgiven by his wife and students, hence showing he maintained the respect of the community. However, Robert Johnson disagreed with Erb's continued employment, and an Erb v. Iowa State Board of Public Instruction filed a complaint to have Richard Erb's teaching license revoked. Johnson claimed Erb was morally unfit to teach because Erb was caught having an extramarital affair with his wife. The revocation was granted, but overturned by the Supreme Court of Iowa, whose ruling stated one admitted admission of adultery did not equate being unfit to teach. In contrast, a court did find another matter related to teacher sexuality worthy of dismissal, that matter being whether a teacher identified as being homosexual. In Gaylord v. Tacoma School District No. 10, high school teacher James Gaylord was discharged due to his status as a publicly known homosexual. Gaylord was questioned about his sexual preference after a former student suggested to a school vice principal that he thought Gaylord was gay. The vice principal confronted Gaylord the same day. Gaylord admitted he was gay and asked the vice principal to drop the matter, to which the vice principal refused, instead notifying the district's board of directors. The district's board of directors determined Gaylord's status was contrary to policy against immorality and discharged him shortly after, on December 21, 1972. The Supreme Court of Washington upheld the decision, stating, after Gaylord's homosexual status became publicly known, it would and did impair his teaching efficiency, and if Gaylord had not been discharged after he became known as a homosexual, the result would be fear, confusion, suspicion, parental concern, and pressure on the administration by students, parents, and other teachers.